Hello, and welcome to today's webinar, GDPR Countdown, Last Minute Checklist. My name is Terry Mock. I'm the Chief Operating Officer at Cybba. We're a digital advertising and performance marketing solution provider. I will be your host for this session. Today we have with us Matt Fearon, vCISO, or Chief Information Security Officer, and Principal of Integrita Security. The European Union's General Data Protection Regulation goes into effect on May 25th, 2018, just a couple of days away. Today, we're going to cover the basic principles and objective of the GDPR. Our discussion will primarily focus on how GDPR applies to you and your company and what you need to do to comply. So before we get started, let's go over a few housekeeping items. Tweet with us using the handle Cybba Inc. and the hashtag #GDPR Countdown. We want this to be an interactive discussion, so please submit your questions throughout the session in the GoToWebinar panel on the side. We will also have time for questions at the end. We are also recording this webinar and we'll make it available to you for later playback and sharing. So let's get started. With the GDPR around the corner, Matt has been quite busy, and I'm delighted that he's able to carve out time for us today. As I mentioned, Matt has his own security consulting practice and is available as vCISO for companies. Matt is also on the board of directors of the National Technology Security Coalition. Previously, Matt was the CISO at Epsilon, a leading marketing technology company with over $2 billion in revenues. He also headed information security at Capital One and JP Morgan Chase. Matt is a recognized expert in global information security, data privacy, enterprise risk management, and IT compliance. And honestly, as we prepare for the GDPR at Cybba, we've benefited from Matt's wealth of knowledge and expertise. And most of all, I would say that I've definitely appreciated Matt's practical advice that has enabled us to prepare for the GDPR here. So Matt, thanks for joining us today.
Thank you, Terry. It's my pleasure, and I welcome any and all questions and advice, participation by the audience, and engagement by all. So I really appreciate the opportunity to speak to this group and look forward to future discussions as well.
Okay. Well, as we've discussed, the GDPR becomes law in less than 10 days. The regulation is and will impact businesses around the globe. Companies are assessing the security policies and protocols to ensure GDPR compliance to the security of personal data. How ready is your business for these challenges? Let's walk through the agenda for this session. Well, we're going to go through, a little bit of the history and understand the GDPR in the context of a company's responsibility for compliance. And then Matt's going to present key steps to assess your state of preparedness. And finally, we review a checklist of GDPR musts. So let's get started with the basics. What is the history behind the legislation? And this would give us good background for understanding the intent of the EU legislation. So talk us through that, Matt.
Thank you, Terry. I appreciate that. And to reiterate the objectives of today, to cover GDPR, here are the key steps that most organizations are going to go through. And then there are some must-dos, and this is what I'm going to finish with today, that will provide you with, look, at a minimum, you must do these things. And there are about 6 different categories that I will want to speak to. Before we get into that, though, the history of what's happening here, I think is very relevant to the conversation and something that really helps set the stage for what organizations need to do, why, and how we got to where we are today. There's a long history in the European Union of protecting EU citizens' privacy and more specifically, their personal information that is available online, collected, processed by organizations, etc. In 1998, the EU put together legislation. It was the data directive for this that was intended to be a model for all of the EU member states to be able to put laws in place and put these principles in practice around protecting EU citizens. It was very frustrating, mostly for companies and organizations to take on a compliance function and understand, what does this actually mean to me, and how am I supposed to be compliant, and how do I continue to perform my business? It was very difficult, it was time consuming, and it was not that terribly effective either for protecting the EU citizens' privacy data or for organizations to utilize as a guideline for what they should and should not be doing. This was primarily in place for a number of years, and the majority of organizations utilized the Safe Harbor program. This was the US, European Union, Swiss Safe Harbor program. It was eventually struck down and it was replaced by Privacy Shield. It was considered insufficient in general, and it was inadequate in terms of restrictions on government interference. And the end game on this was it essentially provided organizations with legal or legislative means to protect the organization from the EU legislation that was out there to provide this protection, and this was eventually struck down. So it essentially put the EU in a position, and the citizens and those regulatory authorities, they didn't have the ability to enforce much of the spirit and the principles and the objectives of the privacy regulations that they were putting. So if we move to the next slide, the general data protection regulation itself was agreed upon in 2015, and this was adopted in that time frame. And on May 25th of this year, May 25th, 2018, compliance is mandatory and required by all organizations. It is regardless of your location, it is applicable to you if you are collecting data on EU citizens. This applies to everyone. And I think this is fairly common information. I think everybody kind of knows this, but I don't think every organization has done their due diligence in order to understand how does it actually apply to them, what should they be doing, et cetera. And then the regulation also provides a opportunity or penalties and fines up to 4% worldwide turnover. So imagine your entire revenue stream for a year up to 4%, or 20 million euros could be what you as an organization could be fined for. Now, this puts the teeth in the legislation that really forces organizations to be compliant. And it is incredibly significant for many companies that clearly cannot afford or have that type of margin, and they certainly want to be compliant to what they're supposed to be doing in this case. But what is one of the factoids throughout this engagement with EU, and in particular the regulatory authorities, the regulatory bodies in all of the member states, which are listed here on this slide, is each one of these has put forth a projection of revenue that they are going to obtain through this legislation as they continue in 2018, 2019, and beyond. That tells me that there is a very strong desire and intent to prosecute, to go after companies, organizations that are collecting and processing information on EU citizens, and if they are not doing so in a manner in which is compliant to GDPR, those regulatory authorities, one or more of them, may come after those companies in order to generate the revenue that supports the programs that they have as they move forward. Now, I believe this to be true. It is a common thread of discussion among those that I have talked to over the last couple of years in regards to this. The reality of what will happen is I'm confident there are going to be fines. There are going to be organizations that are going to hit the news. There will probably be some small to mid-sized businesses that will have fines. It is yet to be known or understood as to how severe those will be and how impactful to the continuing operation of the business that will be, and reputational damage may be incurred as well. I think large organizations may be insulated to some degree in the sense that they will be able to apply very significant legal challenges to the EU. I recently sat down with a very large global financial services organization, and the individual that is responsible for GDPR shared insights, and it was part of the deep conversation around what they're doing, not doing, et cetera. And they feel incredibly confident that, one, they not only are already compliant, they will continue to maintain compliance, but they are also confident that they will be tested by the regulatory authorities, and that part of their strategy is to put up an incredibly strong legal defense as well. So not all SMBs are going to have that capability. So investing in ensuring you're compliant is going to continue to be a significant strategy item for anybody to operate with and to be cognizant of as we move forward. Next slide, please.
Well, hey, Matt, I just want to interject there.
Yes.
So you're saying that you think the EU is really going to fine and actually pursue, compliance to the GDPR. What is your sense of how many companies are ready for the GDPR? Because I've read a number of articles, the latest one from late April in Martech, that some say 60% are ready, 40% are ready, 95%. I mean, it just ranges all over the place. I know as we've worked with customers, there's still a lot of questions open in terms of the readiness of different organizations.
Right. And I really feel like those numbers are probably very realistic in that we know that not 100% of all the organizations are compliant. There are many organizations that have not invested any time, effort, due diligence into preparations already. And there are many that are aware but have not necessarily taken any actionable steps within their organization to be compliant. Is it 60%? That may be a high number. It may be a low number, but I am confident that it is a statistically significant portion that are not compliant, and I am confident without a doubt there will be fines, there will be action taken, there will be many legal cases as we get into 2018 and beyond. How significant they are and how impactful they are to those organizations and how many headlines are made out of that are yet to be seen. But there's been a tremendous amount of investment in this by both the regulatory authorities as well as companies and organizations that are operating and collecting data out of EU citizens. I'm confident that you're going to see a lot of activity as a result over time.
Okay, well, let's keep moving ahead in terms of just understanding the definitions and objectives of the GDPR. Like, who does it protect? Who is responsible? What are these terms in terms of a data controller versus data processor? Yeah, let's just walk through some of those.
Yeah, so the objectives of GDPR, essentially, and this is a very high-level simplification of this, of GDPR to a degree, but it will give the EU citizens control over their personal data. It allows people, natural persons, to be able to take back control over what information exists on them in cyberspace with these organizations, with those that are collecting information, and be able to control it. It also had the goal of simplifying the regulatory environment for businesses. So all of that frustration and the questions, and then the fences used through the Safe Harbor program against the prior legislation, this was intended to simplify that. Now, it is a very questionable and debatable topic of, is it really more simple today than it was in the past? I think most organizations would argue that it is not, but it is very specific around what the fines and penalties and the actions can be against an organization. And since it now has much more teeth, it does require every company to pay attention, to be aware, and to do what's required. Other objectives here, it gives EU citizens and businesses, they can fully benefit from the digital economy. This is a business case for, there's a very significant market out there, as you all know on this call, around the collection of information and data and use and analysis and big data analysis, et cetera. And they want to be able to pull some of that benefit and control some of that benefit themselves. In the EU, the citizens as well as the regulatory authorities. It applies to every organization, regardless of whether you're based in EU or not. If you're collecting data and it's on an EU citizen, a natural citizen, resident there, it still applies. It applies to both controllers and processors. Now, this question comes up a lot, and I think there's been some false security or some false confidence that has been in place for really a while now by a lot of processors that, well, that's the data owner or their client's responsibility to be compliant. That is not true. There are very specific implications and requirements for data processors, and there are very specific requirements for controllers, and there are some requirements that apply to both controllers and processors. The controller is that entity that actually owns the relationship. They control what personal data is processed. They're responsible for the processing purpose or the intent and the legal viable rationale for why are you collecting and processing this information. And then the processor is obviously the one who's providing some of the service, a back office type service or a secondary service, a sub-processor. They are to only use the data as instructed by the controller, and they cannot use the data for some other purpose. So if you are currently considering yourself a data processor and you're processing on behalf of a controller, but you're collecting that data and utilizing it for other purposes, you had better look into data controller requirements, because by many definition and many opinions, you are also a controller. It's something that you really need to know, understand. You need to get expert advice. You need to have an assessment performed, and you need to become compliant in very short order at this point with less than 10 days to go, or certainly have a plan in place to become compliant as soon as possible.
Well, we have a question that came in, Matt. If you're not prepared, is it best to just block your website from being viewed by customers in the EU until you know you are in compliance?
Great question. That's a business decision. So I think that you're going to have to balance out how much is that business there is for you. What is it worth to you and your organization? And is it worth blocking that and having a negative impact on your overall business model, your revenue stream, your business as a whole? Should you do it? Possibly, even if it is for a very short time frame, in order to take the time to assess and look at your environment and say, am I compliant and am I spiritually aligned to the GDPR objectives and the regulation that's out there? And do I have appropriate security controls in place for an organization my size and for the capabilities that I have? There's no expectation that every small, medium-sized business is going to be able to operate with the same level of compliance controls and investment and security functions as a large financial global bank. That's just not expected. There's also the expectation that you do have a right to do business. And so the GDPR legislation is not absolute. It doesn't say you can't do things as much as if you do something, here's what you have to do and what the steps you have to take in order to be compliant and be secure.
Okay, and then another question, what rights, can you clarify a bit on what rights individuals have under the GDPR versus, I think you alluded to this, rights that companies have under GDPR?
So another great question, and this is one that's really very new to organizations, especially. They're primarily, now there's a lot of complexities in here, but it kind of boils down to 4 rights that are very prevalent and kind of in the mainstream media and news about here's what they can do. If they have the right to access, and that means an EU citizen can reach out to an organization, they can reach out to you, and you must have a channel for them to reach out to say, show me what data you have about me. And you have to provide that. Now, there are nuances between sharing intellectual property and actual PI data. And you're going to have to perform some analysis and figure that out and only share what is appropriate and what does not harm your organization. But at the same time, you do have to do this, and you must do this in a time frame that is acceptable and reasonable per the regulation. And you're going to need to understand what that is, how long you have to do that, et cetera. Individuals also have the right to rectification or correction. So if you have information, and as an example, if somebody has information on me and it says that I'm a 30-year-old female, well, I'm not. I'm definitely not 30, and I'm definitely not a female. I have the right to change that. And there's other pieces of information about me, whether that's metadata about me or in terms of my likes, interests, et cetera. I have the right to have that corrected and changed. And most organizations, and virtually every organization I have talked to, did not originally have the ability to even take this request, much less execute on it and change their records. This includes backups, archived media, et cetera. Now, I think the reality is the regulatory authorities are not going to pursue you if you didn't change this on a backup. But we don't know that for sure, and we're going to see what happens in time. Another right they have is the right to erasure. So they can call in, they can request, they can send a request to you as an organization. And again, you have a limited amount of time in order to take action and confirm this. That you have to remove or delete or erase the information you have on an EU citizen. Again, almost every organization that I have talked to did not have the ability to do this. And I would venture to say most still do not have the ability to do it at scale and probably have a very clunky or difficult process to follow in order to remove that data today. And it also applies to archived backup data, et cetera. And then finally, there's another significant right of individuals is data portability. This one is a little more nebulous in terms of having significant impacts to organizations. This is to say, if the citizen were to reach out, especially to an organization like this, and say, I want you to move your information that you have about me from you to another service provider, an advertiser, et cetera, that's not really going to be required. But it was meant to be able to provide portability of information between service providers that, maybe it's for a health service provider or something similar in nature to that allows an individual to more freely move themselves from one place to another. There's even been examples of, well, if I'm a banking customer or one institution and I want to change banks, I want to be able to pull all of my information and take it over to this next one easily. And it's a little bit, I don't think it receives much focus right now by most organizations. And I think we'll get clarity around how it's really going to pan out around that particular right for individuals over time. And I think that most of the people likely in the audience for today's discussion probably don't have a lot of responsibilities as it relates to portability in this case.
Okay.
And those are the 4 primary rights that individuals have. And this is not something that U.S.-based companies are used to. And so not being able to respond to these in a timely manner can be very detrimental to your business.
Cool. So just to summarize, individuals have rights, EU residents have rights to access, rectification, erasure, and portability. That's really good to know. We have some follow-up questions to that from our audience. What about B2B and implied permission? For example, a person gives their business card to another business to receive email updates.
So I believe that this is clearly a scenario where you have specifically given consent in order to perform a communication, to collect that information, to use that information for your business. It is not a one-way transaction, however. It is not, I'm giving you my business card or a piece of information and therefore I am forfeiting all my rights. That clearly is not the case. It is, if you are accepting that information, if you accept my card and you're going to use it, you are also consenting to the fact that you will be compliant to protecting it and to keeping it secure and to give me the ability to exercise my rights as well as be compliant to GDPR for this in the first place. And you have a legitimate reason for having that information and you're going to use it for the right and intended purposes. Yes, B2B certainly comes into play. It's questionable as to whether you're going to be considered a processor, sub-processor, controller in those relationships, but by far and large, whoever it is that originally accepts the information is considered the controller in those cases, and anybody else after that would be a processor or sub-processor in general.
Right, but the act of giving you the card, knowing that you will likely get follow-up emails, does it have to be documented, or is it okay that it's implied? So there is consent that I would be, or somebody would be providing consent. You do have a requirement that you have to log or track or provide evidence in some form or fashion around that consent. You can't just say, well, that somebody gave me a card and not have any ability to substantiate that. You have to provide that to some degree. So you have to track it and keep track of that and use that as your basis for consent as you go forward. How you do that is up to you as an organization, and it is there's every possible mechanism you can imagine is being employed, short of I don't think anybody's doing it manually per se, but just having the card in your hand is not necessarily
constitute valid tracking mechanism for that consent either. So you have to put something in place.
Okay. Then another follow-up question regarding the right to erasure. Do we have to remove everything? What if we are audited by the IRS? And maybe that you could speak to some of the rights that companies have in terms of freedom to conduct a business related to that.
So if there's, obviously if there's legal requirement, whether it's IRS, tax laws, payments, et cetera, you have to keep records yourself for these things. And nobody can make a request that you have to erase that. If it was, then if you could do that, then I would call all of my organizations and say, I want you to erase all of my payments to me just prior to them submitting it to the IRS every year. And I would never pay taxes again. That's not obviously something that you can do. Those are not rights that the EU citizens have. They also do not have the right to require you to delete all data, but they do have the right to require you to delete all data that is personal information to them and is non-material, not required for your business for other tracking, logging, other regulatory requirements, et cetera. So if the information you have is required for any other legislation, any other regulatory requirements, any other compliance functions, then that would take precedent and the GDPR right to erasure would not apply.
Okay. Well, let's move ahead. You spoke about the type of data and personal data. So I really want us to understand the definition of personal data. What kind of information does GDPR apply to? And what are some examples of this personal data?
Okay. This was, especially in the beginning with GDPR, this was one of the most talked about components of GDPR in terms of what does it actually apply to. And it's one thing to say personal data or personally identifiable data. GDPR and the legislation that was put out there really went into the granular details around how the industry and how really the world of marketing and other cyber-based data and analytics organizations work to understand what is that is considered personally identifiable or something that can identify an individual. So you have your legacy kind of stuff, name, your address, phone number, et cetera. But it started to expand and it includes location information, IP addresses, cookies obviously are part of this now. And it started to really explode into a lot of factors that were not historically considered PI data, especially in the US. And those, that data is essentially, in every organization that's out there. Whether it's, online identifiers like cookies that I talked about, or it could be just a identifier that you have created. It could be a randomly generated identifier, and by itself may not be PI data, but combined with any other information that could be used to identify you would be considered personal data or PI data. It could be portions of data, such as IP addresses in their entirety is considered PI data, even if IP addresses are randomly assigned or constantly evolving and changing. It's still considered PI data, and you can argue that with the technologists, you can argue that with security folks, you can argue that with whoever you want. EU still considers it PI data, and there's nothing we can do about that. Portions of an internet protocol or an IP address can also be considered PI data if it goes down too far. So if it gets an individual's location down to a very specific region within a specific country, within a geographic area, that's considered PI data. Obviously, biometrics, photos, images, things like that would also be considered PI data. Any kind of websites, URLs that are very specific to an individual would be considered PI data. And then the thing that is most concerning about this is there's this nebulous component around the definition of personal data under GDPR that really opens the door for the regulatory authorities to bring into the definition of personal data things that currently are not or currently unknown. So when they say one or more factors specific to physical, physiological, genetic, mental, economic, cultural, or social identity of that person, well, what does that mean? And in essence, if you were to really analyze the legislation, it is if you collect any information, and that information can either directly or indirectly tie data and information back to an individual, all of that is considered PI data. Or you should certainly consider it PI data and treat it as such, because you're running the risk that that the regulatory authorities may bring it into scope. Things that are not PI today may be in the future. You have to be very careful. And in reality, part of the rationale or the thought process that many people have around this is an attempt by EU to say, if you don't have a very specific, legitimate reason to collect a data element, then don't. They don't want people to, they don't want organizations to just collect all information that's available and then only need a portion of it, but have the other pieces, other data elements, other metadata. They want you to only get what you're required to have to support your business of what you're doing for the transaction at hand, and use it for only that purpose, and then get rid of it or not use it for anything else. That is what they want out of this.
Well, Matt, that's a very, very broad definition of personal data, and it's rather expanded from PII data as we understand it today. I'm sensitive to the time that we have, so I'm going to keep moving along. I think we really want to get to the key steps for preparedness and what must be done. So walk us through the key steps and what must be done.
Yeah, I'll go over these at a pretty high level, and then we can get to the absolute must-dos. First and foremost, make sure you have awareness and you have a individual in your organization that is responsible, has accountability for compliance to GDPR. Make sure you have that single or either a single person or a single group that's doing that. Understand whether you're a controller or a processor or both. I think there's a lot of organizations that consider themselves a processor, and in reality, they are also a controller. You must do an inventory of your data, and you must do a data protection impact assessment. And there's a very specific assessment that can be performed in order to do this on your data, what you're collecting, et cetera. You need to make sure you get your third parties assessed, or you get an attestation, or and preferably an attestation, or some other type of validation and substantiation that your third parties are compliant to GDPR. You should, if you're considered in scope for GDPR based on assessments up to that point, you do a risk assessment for your entire organization. That's a much more complex function, and you know, I can certainly speak to that offline or in subsequent conversations if needed. You have to implement privacy by design in all your products and services. So from the point of creation all the way through to production and actually execution, things have to be built this way. You should have a data classification process in place that really helps you understand what data you have, and it is something that can go hand in hand with your scoping and data inventory. You need a security awareness communication program, something in place that ensures that the appropriate security controls for your organization, for the data that you have, for the volume and amount of data you have, and is in line with the capabilities of an organization your size. That needs to be in place. And that can be a complicated item to ascertain, and you may need help in understanding that. You need to make sure that you have a very straightforward communication of your privacy policy. It should be very easy to obtain. It should be in clear language. It needs to be readily available to those that are visiting your site or utilizing your services, so that they know what information is being collected, who do they contact, and gives them essentially the front door to engaging with your organization. You need to know the individual's rights around lawful processing and accessing requests, and this goes back to some of the items are there, as well as the next one around explicit consent, access and rectification and erasure. The explicit consent can be a very complicated item. I would highly recommend that you engage with your data owners if you're not the data owner, and if you are the controller. If you are the controller, you certainly need to make sure you have the appropriate individuals and legal and others involved in order to understand, are you gating consent in an acceptable manner, and tracking that and logging it, keeping it, archiving. There's very specific rules around children, those under age. Generally, this doesn't come into play too much for most organizations that I've dealt with, because they already had something in place that was acceptable in terms of processing data for children, or in particular not processing data for children. From a security perspective, the requirements are not overly extensive, and most organizations that are large organizations are going to have a security program that clearly meets a standard set forth of the GDPR. But for small and mid-sized businesses, there are some minimal security controls and measures that must be in place. Making sure that you have data protection by design, you have an adequate incident management process, and you have reasonable security controls. And the reasonable security controls can be somewhat flexible and nebulous depending on your point of view. You might need an expert to help you understand what that is and whether you're compliant or not. And then, depending on your organization, how much data you have and how much of it could be impactful to EU citizens, you may be required to have a data protection officer established in place, and that may have to be in multiple countries as a result. You may have to have multiple individuals. It depends on how much data you have, how large you are, and what the impacts of that is.
Okay, well, that's a lot of steps to take, but if we had to drill it down to the absolute must, let's walk through those things.
I would say, if I were providing advice to an organization today who has not really invested anything into being GDPR compliant or understanding the due diligence around whether they are not or need to, I would say do these 6 things very, very quickly, and make sure that you have a plan in place to address them, because this would at least provide some level of assurance and protection and defense in terms of being compliant to GDPR. 1, make sure you have full awareness and responsibilities vetted across your organization at the top level. The business owners, the executives of the organization must have awareness of GDPR, what it means to them, its impacts, and what their requirements are. Get on top of your third parties. Make sure they are GDPR compliant. Get an attestation letter. Utilize whatever you can from them in order to ensure that they are also GDPR compliant. Explicit consent. Make sure that if you are collecting any information as a data controller, or if you're a processor, ensure the data controller is obtaining explicit consent to gather the information. And it can be a complicated process in order to go through that to ensure that you are, but you must do this. This is not something that you can imply this. depending on, again, the size of the organization, you need to have, or you may be required to have, a data protection officer put in place. You must have very specific roles, responsibilities, and requirements of what that individual is going to do, what they have authority over, and who they report to. You may need to invest in that. From a security perspective, a data breach or security incident reporting mechanism, you must have an ability in a very short time frame to identify that a breach has occurred or a security incident has occurred, that it has impact to the PI data for EU citizens, and you have to notify all appropriate supervisory authorities or regulatory authorities in the EU about that. And you do not have weeks or months to do this. You have hours and days to do this. Most companies do not have this capability. It's very difficult for them to employ this. I would suggest, everything here, if you don't have that, you are in great risk of having difficulties with EU if an incident were to occur. And then lastly, make sure you have at least some kind of plan to deal with the rights to access, rectification, erasure, and portability. At a minimum, have ability to respond to individuals that make these requests so that you can give them some kind of information and action that you're going to take. I would do these at a minimum. I would not qualify all this and say that if you do this, you're good. I'm saying do this to help protect yourself as much as possible, and then build a longer term plan to be GDPR compliant if you were coming into this today and you hadn't performed anything.
Well, that's great. That's really helpful. We've covered a lot of ground today, understanding GDPR and each company's responsibility for compliance, assessing state of preparedness, and then the checklist of GDPR musts. There's just some time for a few questions that came through, so let me just ask them real quick. In the chain of data ownership, what is the responsibility for each party? For example, for the data controller versus the data processor or the data sub-processors?
So this one is, I hear this a lot, and frankly, you can't summarize this in a simple response. There are very specific requirements for data controllers. There are very specific requirements for processors, and there are some requirements that are for both. In essence, if you don't know if you're a controller or processor, that's a problem. You need to figure that out. Whichever one you are, or if you're both, you need to get into the legislation and truly understand all of the requirements. And there are literally hundreds of different requirements that are out there, but by far and large, a lot of organizations already adhere to these, whether by design or not. But you need to do an assessment. You need to figure that out yourself. You need to get somebody engaged to help you figure that out. It is not a simple 1, 2, or 3 sentence response to what are the full responsibilities for a controller versus a processor.
Okay. And then last question, since we're running out of time, will the GDPR apply equally to large and small companies? We are a SMB e-commerce site and can't afford a DPO.
Yeah, so in terms of, okay, does it apply equally? And I'm going to say, initially, I'm going to say the answer is yes. Is your response and the investment that you have to make in order to be compliant the same as it is for a large organization versus small? The answer is no. It is relative to your size, your capabilities, and your abilities as an organization. Now, that does not mean if you're a small organization, you have to do nothing. There is a minimum floor level of requirements, especially around security and consent and some of the other requirements that are out there that everybody must do no matter what. But there is a significantly larger expectation for large organizations to have a very robust compliance program and a very robust security program and be certainly operating within the spirit of the objectives of GDPR, and to have a very tightly managed, controlled environment as they move forward. So it applies to everyone equally, but the investment required is different from everyone. Hopefully that makes sense.
Right. Well, thanks for your great insights, Matt. I think we got a lot in terms of working with Matt for our compliance preparedness. And I would suggest if you have any questions, certainly follow up with him, and he's available to support you. As we wrap up, I just want to indicate our upcoming webinar on remarketing emails, a great way to ensure your brand stays top of mind and convert any abandoned customers when they're ready to buy. And that's next week, next Thursday, May 23rd at 1 p.m. Innovative strategies to boost conversions via email remarketing. Finally, I just want to say thank you to both Matt and our audience for joining us today. Please continue the conversation with us on social media via our handle @Cybba Inc. or email us at marketing@cybba.com. If you have any questions related to this, we will certainly pass them along to Matt to answer them and support you in any way. Thanks again, everyone.
Thank you.
Done.